Hi, and welcome to Legal Studies. Today we're going to be learning about sentencing indications. So where are we in the study design? Well, you will have just finished learning about plea negotiations, and sentence indications are all bundled up in the same study design dot point. And the reason behind that is that both plea negotiations and sentence indications are one of the steps we take before a trial to try and prompt a person to plead guilty, to try and resolve the case early. So what do you need to know for this topic? Well, the first thing you need to do is to be able to define sentencing indication, know what it is. And then the second thing you need to be able to do is to be able to explain to me when should we use them and when should we not use them. So in other words, when are they going to be appropriate? What is a sentencing indication exactly? Well, essentially, a sentence indication is when the court tells the accused person, if you plead guilty right now, this is what's going to happen to you. So it's an indication of the sort of sanction they're going to get. And the accused can ask for this at any stage during proceedings. Now, there's a slight difference between what a sentence indication looks like for a summary offence in the magistrate's court versus what it looks like for the indictable offences in the superior courts. So in the magistrate's court, when you ask for a sentence indication, what the magistrate can tell you is a little bit broader. They can tell you a bit more information than you'd get in the higher courts. So when you ask for a sentence indication in the magistrate's court, what they can tell you is the type of sentence you're going to get if you pleaded guilty right now. So they could tell you, if you plead guilty, I'll give you a fine, or I'll send you to a community corrections order, or if you plead guilty, you will in fact go to jail. So they can tell you the type of sanction you're going to get. What they can't tell you is how long your sentence is going to be. They can't tell you how long you would go to jail for. They can't tell you how big your fine is going to be. So they can tell you the type of sanction, but not how long it will be. And with both types of sentence indications, whether you're at the magistrate's court or the county or Supreme Court, if you plead guilty after hearing that sentence indication, the court can't go back on their word. So if they tell you you're not going to jail and then you plead guilty, then they can't send you to jail. It's a little bit different at the higher courts for the indictable offences. The main difference is they're a little bit more limited in what they can tell you, and they can really only tell you whether or not you're going to get a prison sentence. So unlike the magistrate's court, they can't tell you what type of sentence you will get, but they can simply tell you whether or not you'll get a prison sentence. So essentially, you're asking them the question, if I plead guilty right now, will I go to jail, yes or no? And that's really the only thing they can tell you. On top of that, just like the magistrate's court, they can tell you whether you are going to jail, but they can't tell you for how long. They're not allowed to. In the higher courts, you can only get a sentence indication if you apply for it and the prosecution has to agree. And further than that, you can only get them one time. So really, the difference between a sentence indication in the magistrate's court and the county court is that it's a bit more limited what you can get in the higher courts. Less information is available to you. So what's the purpose of this process? Why do we have a system where you can ask beforehand what sort of a sentence you're likely to get? Well, the whole point of it is to give the accused person some clarity. Let them know with some confidence what will happen to them if they plead guilty. Because if we do that, then they're more likely to plead guilty, and that's going to save the court time and money and stress. Because if you ask the court, hey, if I plead guilty right now, what sort of a sentence am I going to get? And the court tells you, well, if you plead guilty, you won't go to jail. Well, that can prompt a lot of people to say, all right, okay, I was really worried about going to jail. I did do it. I am guilty, but I really didn't want to go to get jail. So I was going to fight it. I was going to fight it the whole way. But now that I know with certainty that I'm not and that I don't have to worry about jail, okay, fine, I'll plead guilty. So that's the biggest reason we have sentence indications. If we give the accused person some certainty about what's going to happen to them, they will be more comfortable pleading guilty. And that saves the court time, money, stress. It saves victims the stress of having to come into court and give evidence, because we don't have to have a trial if they plead guilty. So that's the whole point of a sentence indication. So when is it going to be appropriate to ask for one of these? Because there are going to be circumstances where you should ask for one, and there are going to be circumstances where you shouldn't be asking for one, where it's not going to be appropriate. One of the biggest things to think about is what sort of offence is this person charged with? How serious is the offence that they've been charged with? Because, to give you an example, let's imagine you've been charged with 21 counts of murder, and you're in the Supreme Court and you're a notorious serial killer. And you ask the court for a sentence indication. You say to the judge, hey, if I plead guilty right now, what's going to happen to me? Well, the answer to that is obvious, isn't it? All right. If you've been charged with 21 counts of murder and you plead guilty, you are always going to go to jail. It's a pointless question. It doesn't help for you to ask the judge, hey, if I plead guilty, will I go to jail? Yes, you will. All right. So at that stage, it would not be appropriate. It would be a waste of time for you to ask for a sentence indication because we already know what the outcome is going to be. It might be more appropriate if you're charged with a crime that's sort of on the borderline. Perhaps you've been charged with an assault. And you know your lawyer is advising you, it's a bit of a toss-up. You might go to jail, you might not. It depends on what the judge is thinking, and that's the point in time when it would be appropriate to ask for a sentence indication, because then you could get the judge's thoughts. If I plead guilty right now, will I go to jail? And the judge will tell you, they'll say, well, no, actually you won't. If you plead guilty now, I will not give you a sentence of imprisonment. And that might change your mind and you might decide to plead guilty. Other reasons include the fact that, well, the judge or magistrate might feel like they don't have enough information. All right, they don't have enough information about the crime, about what's happened, about the impact on the victim, to be able to properly give you a good answer about what will happen to you if you plead guilty. We might have really weak evidence against the accused person, and they might have a really legitimate defense. And in that case, it would probably be inappropriate to ask for a sentence indication, perhaps because we don't want to try and pressure innocent people to plead guilty. And that's what a sentence indication can do. So there's all sorts of reasons why you should or shouldn't ask for a sentence indication, and it's all going to depend on the circumstances. And all of your exam questions are going to be about, in some way, here's a scenario, here's a circumstance. Would it be appropriate to ask for a sentence indication here or not? All right, and that's it for sentence indications. I'll see you in class.